So I have an update in a case that deals with a state's ban on rifles and magazines. So something important has now developed that we need to talk about. Now, really quick before we jump into this video, I actually have an announcement to make. One of the things that I've been working on for a while was trying to provide you guys with more resources so that if you're interested in knowing more 2A law and just having the information that you need more readily accessible to you, providing you guys with those tools. And one of the things that I now have available is a Second Amendment legal guide. I will have a link to it down below. For full transparency, it's going to be just $10 a month. So for just a cup of coffee a month, you give that up, you're going to get access to this guide. You're not obligated to sign up, but if you're interested, I will have a link to that down below in the detail section and then also in the pinned comment. Now, as I mentioned in the intro, in this video, I have an important update in a case which was recently decided, and it deals with a challenge to a state's ban on so-called assault weapons and then also magazines that hold more than 10 rounds. The case we're going to be talking about here was actually a few consolidated cases, the A&J RPC versus Platkin case and then also the Cheeseman case. And both of these deal with the state of New Jersey's ban on so-called assault weapons and then also magazines. You may recall that recently, I believe just last week, we put out a video where the lower court there finally issued their decision. And what they did is they granted partially a motion for summary judgment as to the regulations and restrictions on certain AR-15s, the Colt AR-15, and essentially found that the state's ban on the Colt AR-15 was in fact unconstitutional, violated the Second Amendment, and did not align with Bruin. But that same court also upheld the state's magazine ban. So it was one of those things where the court tried to keep the decision as limited as possible, tried to give the most narrow win possible, and we knew that essentially the state and also the plaintiffs here were not going to like that decision. And now the state of New Jersey themselves have appealed the granting of those cross motion for summary judgments, have appealed that, and they now want the circuit court to reverse what the lower court did. So essentially they're still complaining even about the narrow win that was given to the plaintiffs. Now, if you're not aware of what's going on with these cases, let me generally break down what's going on, and then we're going to talk about what implications and what's going to happen going forward. So back in June of 2018, the state of New Jersey passed the Assembly Bill 2761, and it banned the possession of firearms magazines that had the capacity to accept more than 10 rounds of ammunition. So essentially just a magazine ban. That New Jersey law essentially required that the owners of those magazines would have to either modify their magazines that they already had to permanently reduce their capacity, they would have to destroy them, or to turn them over to law enforcement. Now, when it comes to the magazine ban, originally there was a lawsuit filed back in August of 2018, and the plaintiffs here, A&J RPC, sought for a temporary halt or block to be put in place on this specific magazine ban, and they sought a preliminary injunction. But the court there, the district court, ruled in favor of the state of New Jersey, and they applied what is known as the two-step approach, which has now been struck down by the Supreme Court in the Bruin decision. And then the case ultimately returned back down to the district court, where on a motion for summary judgment, the same district court judge granted a summary judgment motion in favor of the state of New Jersey, upholding the entire magazine ban. So that was a final merits decision. So once again, the plaintiffs then appealed up to the Third Circuit on that final merits decision, and A&J RPC argued that the earlier Third Circuit panel's ruling was not binding on this new panel, that the magazine ban or upholding the outright ban on magazines was clearly a violation of the Second Amendment. But back in September of 2020, that new panel rejected all those arguments and upheld what the lower court said, essentially finding that the magazine ban was in fact constitutional. And so that led for the first time the A&J RPC magazine ban case to seek Supreme Court review, and that was back in 2022. But that was right before the Bruin decision. And what the Supreme Court did is they put the A&J RPC, the New Jersey magazine ban, on hold. Essentially, they waited on that case until they issued Bruin. Once they issued Bruin, striking down intermediate scrutiny and means end scrutiny in the two-step approach, they reaffirmed that text as informed by relevant history and tradition is the appropriate analysis. They then granted, vacated, and remanded the A&J RPC case back down to the lower court for reconsideration in light of Bruin. And then the A&J RPC case sat for a really long time, but just a couple weeks ago, we finally got a decision from the lower court. And we all anticipated that the district court here was not going to drastically change that opinion. Of course, it was going to be hard to rule the same way under the Bruin analysis, but a lot of lower courts are just outright defying Bruin or trying to find weird end arounds when it comes to Bruin. And that's exactly what this district court judge did here in this decision. What the judge did here with this decision is he found that the specific language as to the Colt AR-15, that the specific restrictions on the sale, possession, transfer, and use of that specific item, that was unconstitutional, that it did not align with Bruin. But then the judge didn't address any of the other assault weapon ban language, and then also upheld the magazine ban. The judge stated in his opinion that plaintiffs challenged the constitutionality of the assault firearms law's prohibition on the possession of so-called assault firearms and a provision within the assault firearms law that regulates the possession of large capacity ammunition magazines to magazines capable of holding no more than 10 rounds. And he states that it is hard to accept the Supreme Court's pronouncements that certain firearms policy choices are off the table. He says that the stare decisis of Bruin and Heller and McDonald, along with Congress not outright banning these items, pretty much forces his hand to find that the AR-15 provision of this specific law is unconstitutional as to the Colt AR-15. Now, one of the interesting things that this judge did in this decision, again, is he tried to keep it as narrow as possible. He argued that since the plaintiffs here had a lot of discussion during the oral arguments and their briefs about specifically the AR-15 and the Colt AR-15, he said that he was not going to address any of the other semi-automatic bans like, AKs or anything like that. He didn't have enough evidence in his eyes, and so he left everything specifically to just the AR-15. And the judge made sure to make that very clear because he said, accordingly, the breadth of this decision is limited by the fact that the remainder of the assault firearms law stands since it has not been challenged. So again, trying to keep it as narrow as possible. And then the judge moved on to look at magazines and the ban on magazines that hold more than 10 rounds. And the judge here did something very interesting because, again, the judge had to apply Bruin and Heller and all the Supreme Court precedent and had to look at the historical analogs and all that. But the judge here first said that clearly magazines are arms. He found that according to the Third Circuit's precedent, these magazines are clearly arms within the meaning of the Second Amendment. And then he went on to say that these magazines, which are arms, are also in common use. He found that these magazines that hold more than 10 rounds are owned in the millions by a lot of people in New Jersey, and the state of New Jersey themselves, through their law, allowed for 30 years people to have and possess these items. But this judge then tried to do something completely different and add in an element to Bruin, and he tried to take the whole nuanced approach based on new societal concerns. Essentially, the judge said that this magazine here, magazines that hold more than 10 rounds, is a new technology, and as a new technology, it has new societal issues that it's caused damage to people, and he goes on a long rhetoric rant about how lethal these magazines are. And because of the new societal concerns, history shows that a state like New Jersey can restrict the possession and use of these items and essentially could outright ban them. Now, also in that decision, the judge stayed the application when it came to AR-15s and everything else for 30 days for an appeal. And we knew that New Jersey was ultimately going to appeal this. We also knew that the plaintiffs, ANJRPC, and then the Cheeseman plaintiffs were going to appeal this. And that's exactly what just happened. You had the state of New Jersey that just appealed the Cheeseman decision. They are arguing that the lower court, even though the lower court kept it very limited to just the Colt AR-15, to just AR-15s, tried to give the smallest win as possible. Even despite that, New Jersey is still appealing, and they're arguing that the lower court was wrong in issuing that decision, and now they're asking for the Circuit Court of Appeals to reverse that. So now this is going to be in the hands of the Circuit Court of Appeals. They're going to be reviewing this final merits decision when it comes to AR-15s and then also magazines, which is going to be very interesting. And then they're also going to have to look at whether or not this lower court appropriately applied Bruin and all the other analysis that is required by the Supreme Court in the Second Amendment. This is, of course, something that a lot of people are concerned about. Also in other states like California, New York, Illinois. We have a bunch of other cases that are also moving their way through the process. The Bianchi case was just decided by the Fourth Circuit en banc panel, and I have no doubt that that is going to be, sought for Supreme Court review. So that's to say that's where currently rifle bans and magazine bans stand. As we get more information, if anything else changes, I will let you guys know. Also, if you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like and subscribe, and never forget this nation was built by armed scholars, and this nation will be maintained by armed scholars.